All right, it is 9 o'clock, so I think we'll get started. All right. Well, welcome to the 2026 Student Rights Conference. My name is Mark Weicker. I have short brown hair. I'm wearing glasses. I have a dark blue blazer and a white shirt and a gray tie. Thanks for everyone for attending. We're definitely looking forward to an engaging 2 days of discussion and learning. The Student Rights Conference is co-hosted by Abdenor Weicker and MyPAC, the Michigan Parent Advocate and Attorney Coalition. Abdenor Weicker is an education-focused law firm operating primarily in Ohio, Michigan, and Pennsylvania, but also representing students and educators nationwide in both litigation and Title IX matters. The mission of Abdenor Weicker is to protect the rights and futures of students and educators. Our conference partner, MyPAC, is powered by the Autism Alliance of Michigan and is a statewide grassroots network advancing educational equity and justice for students with disabilities. Through community engagement, strategic organizing, and policy advocacy, MyPAC equips families and professionals to drive systems change. We are incredibly grateful to have Heather Eckner and MyPAC as a partner, as we believe that hosting this conference advances the missions of both organizations. Our hope today is really to come together and share our collective knowledge about student rights with the ultimate goal of strengthening the skills for those of us who are advocating on behalf of students. This year, we have 12 different presenters from 7 different metropolitan areas, all with unique perspectives and experiences in student rights. The conference is intended to be accessible and interactive. You might notice there is a closed captioning option at the bottom, which any individual attendee can use. We have a Q&A, and we expect that to be active today. You can ask questions through the Q&A rather than the chat. And for each workshop or presentation, we'll have 2 assigned attorneys to answer questions for each session. And if a question can't be answered by the assigned attorneys through the course of that presentation, we'll try our best to pose the question to the presenter at the end of the session. We'll have about 10 minutes, 5 or 10 minutes at the end of each 50-minute session for questions. And at the end of the session, you can put any questions in the Q&A. One thing that's come up in the past that we want to remind attendees about is that if you happen to have a state-specific question, just please provide the state in the name, the state in your question, and we'll do our best to answer that question if we can, but we may need to follow up and can follow up if we have to after today's session. You may have noticed that the webinar is being recorded, and the recordings will be made available for attendees on the main conference page, and that is lawyersforstudents.com/SRC. And Elizabeth, if you wouldn't mind dropping that in the chat, that would be great. And these recordings are typically made available within 7 days after the conference. We will pause the recordings at breaks and at lunch. The slides for every session are available at the same location, just listed with a link available next to the session title. We will have 10-minute breaks at the end of each hour. So before you go on break, we just ask that you please fill out the session evaluation. We do have a session evaluation for every session. We have 6 a day, 6 today and 6 tomorrow. And we just ask that you complete this right before you go on the 10-minute break for all attendees. It is short and quick and easy, and we'll put the link in the chat box at the end of the session. We'll also have an end-of-day attendance verification to submit CLE credit, and this verification includes a place where you can put the state, your state for which you are seeking credit. And for Ohio, it'll also have a place that you can put in the activity code, which we'll give you at the end of the day. Through the course of the day, the sessions will have poll questions occasionally, and we will announce when those are posted in case you're just listening in. We'll try very hard to stay on time, and we'll give speakers a 10-minute warning, which is an indication to wrap it up and get ready to take some questions. And we'll want to try to leave about 5 minutes for questions if we can at the end of every session. And we will cut the speakers off when their time is up, with 10 minutes to go in the hour. We want to stay on time, so just do your best to get back from breaks, from each of the 10-minute breaks, and then we have a 1-hour lunch, so please do your best to get back on time after lunch. I think I've covered everything, and I'll turn it over now to my friend and colleague, Jacquelyn Kmetz, for our first session, which is titled Special Education Case Law Updates. Jacquelyn?
Hi, good morning, everyone. My name is Jacquelyn Kmetz. I have brown hair. I'm wearing a navy blue dress with puff sleeves and some embroidery on the bottom of those sleeves. It's good to be here today. I am a part of our Michigan team, so I practice all across the state of Michigan. I work remotely, primarily from Northwestern Michigan in the Ludington area, is where I call home. Which is nice to be by the beach. I do education law, so primarily special education, as well as college education cases representing students for grade appeals, dismissal appeals, or conduct appeals. And then I also work in employment law, representing clients for any disability or age discrimination or other types of discrimination, and also representing them for breach of contract and wrongful termination. And so it's good to be here today. And without further ado, I will get started. So as Mark mentioned, my presentation is on special education case law updates. So I'm going to go through court decisions related to special education, whether that is under IDEA, the Individuals with Disabilities Education Rights Act, or under 504 or ADA, so the Americans with Disabilities Act, to the extent that it relates to K-12 education. And I'm going to go since last June, so just before we had last year's conference, and then carry us into what I've gotten from this previous June. And I'll kind of do it like a hierarchy. So I'm going to start with the U.S. Supreme Court, and then I'm going to shift to the Sixth Circuit. And I chose the Sixth Circuit because that is where I practice primarily. And I know most of our attendees are from either Michigan or Ohio, both of which are in the Sixth Circuit. So I started to highlight there with our circuit decisions, district court decisions within the Sixth Circuit. But then I also will end with decisions from other circuits that have occurred within the last year, and also any other cases to keep an eye on that are still working their way through the court system. And so for each case, I'm going to give an overview of the facts, what the court decided, what the issues were, what the court decided, and what that means for you moving forward as you either practice and represent clients or advocate for clients, or if you are a parent, just advocating for your child, how you can use these court decisions in your work with the schools. Go ahead. And two practical takeaways that I hope you take from this are recent updates to special education law around the U.S. Hopefully you learned some new things, but also, again, how to apply these updates to your own casework. Okay. So starting with the Supreme Court, last June, we had a decision come out. It was AJT versus Osseo Area Schools. And this was pretty big. It was really focusing on the Americans with Disabilities Act and Section 504 of the Rehabilitation Act, looking at what is the burden of proof when an attorney brings a case under Section 504 or the ADA. Up until this case, a lot of courts were requiring what is called a bad faith or gross misjudgment standard, which meant that you really had to show that the schools were intentional in their actions of discriminating against your child and their accommodations that were needed. So it was really a high burden for these, education cases. So in AJT, AJT had epilepsy and so could only attend school for half a day. Really struggled getting there in the morning. And so the parents were requesting accommodations and support such as evening instruction. That way the the student would just have a longer school day to make up for that time missed in the morning. However, the school repeatedly said, no, no, no. Instead, they provided some one-to-one instruction, a slightly extended school day, and then they also offered instruction at the home during the summer. But again, none of this was really sufficient to make up for the fact that AJT is struggling each morning to get to school, and that's a lot more instruction time missed. The district's 504 coordinator apparently wasn't aware of the complaints and didn't realize that, the district could provide this at-home instruction as 504, as a 504 accommodation. So parents ultimately sued the district, alleging the disability discrimination, and the court holding the parents to that bad faith or gross misjudgment standard ruled in favor of the school and said, nope, there was no bad faith here. So, parents, I'm sorry, you lose. Parents appealed to the Eighth Circuit. The Eighth Circuit, again, applied that bad faith or gross misjudgment standard, and parents lost again. And so they ultimately appealed to the Supreme Court of the United States, where they finally got their favorable ruling. And the Supreme Court held that this bad faith or gross misjudgment standard is no good. You can only apply the standard that is held in other discrimination cases. So where you're dealing with like a mall or a workplace or a movie theater, kind of where those other contexts are. And so the appropriate standard to apply was simply deliberate indifference. And so the court specifically stated the Eighth Circuit's continued application of its heightened standard conflicts with Congress's clear directive that the IDEA does not limit other federal anti-discrimination laws. By imposing a higher burden of proof for educational claims compared to other disability discrimination contexts, courts effectively read the IDEA as restricting the independent rights and remedies that Title II and Section 504 provide to disabled children. So the court said, by doing this heightened standard, you're really kind of violating IDEA, that Individuals with Disabilities Education Rights Act, because that act is not supposed to limit remedying other areas of law. So what does this mean for you as an attorney or a parent? What it means is that if you are alleging that the school has discriminated against your child on the basis of a disability, you only need to show that they were deliberately indifferent. And so what that really means is that they knew of this, that there was a protected right, and they just kept, and if their actions would violate that protected right, and they just kept doing it anyways. So that is the only thing you need to show, is that deliberate indifference. And so real quick, we're going to take a pause and jump into our poll question. So do you make a conscious, dedicated effort to stay up to date on the decisions coming out of circuits other than your own, and thinking about if or how you could apply those findings to your own practice? All right, and it looks like we are about done. Everyone's answered. So we actually have a fairly even split between yes, no, and sometimes. 25% yes, 30% no, and 45% sometimes. So that's good. Props to everyone that is staying up to date on these things. And I see we have a hand raised. If you have an immediate question, I'm going to ask that you put it in the chat. Otherwise, keep your hand up, and at the end, I will go through questions. All right, so like I said, going to jump into Sixth Circuit first, because I know that's where most of our attendees come from, is Michigan or Ohio. And the Sixth Circuit this past year really had two big cases. The first one is Abraham Al-Zandani versus Hamtramck Public Schools. That was from May of this year. And then you also had GE versus Board of Education, and that was from from February of this year. So starting with the Al-Zandani case. So in this case, the biggest issue was on exhaustion. So under the Individuals with Disabilities Education Act, before you can proceed to federal court, you need to exhaust those administrative remedies. So you have to go through the due process. You have to file a complaint, and you have to get to a hearing. And so here, what happened is there were a group of parents that filed immediately in federal court. So while some of the parents had filed state complaints with the Michigan Department of Ed, none of them filed that due process complaint that they were required to exhaust, and they just jumped right to federal court. And what they were alleging is that the district had some understaffing issues and was really engaging in systemic violations. So they weren't funded properly. Again, staffing wasn't where it needed to be. And because of these systemic issues, their students were denied FAPE. And the reason they argued that they could go straight to federal court was that it was a administrative exhaustion requirement, administrative issue, and that there was really no individual relief that would be sufficient, and they needed the class action relief. So it was a systemic violation, not just individual. And the court said it doesn't matter. Under the law, there is no such thing as a systemic violation exception for IDEA. The parents have to individually exhaust due process first. Specifically, the language of the statute, when you're appealing to federal court, it says you have to be aggrieved by the findings and decision of a due process decision. And so there is no due process finding to be aggrieved by if you never even filed it. And again, also the court said too, even if you're looking at class action, because IDEA is so premised on that individualized education plan, everything is individualized, even where there may be some overlapping issues among the individual plaintiffs. There is still a lot of individualization and individualized relief that could potentially be looked at. So you have to exhaust at your own level first, the due process. So again, what does this mean for you? Before you even think about stepping into federal court, you have to file your due process complaint just to get that exhaustion required, and you have to go through that hearing. And then, we're going to go back one more time. All right, and then looking at GE versus Board of Education. This one originated down in Tennessee. Getting my T's mixed up this morning. So down in Tennessee. And so GE, he had anxiety, depression, other mental health conditions. And so there was some struggles through 5th and 7th grade. School knew of the anxiety, but he didn't really have any clear issues in the classroom. Rather, he had a lot of absences. However, when the parents were calling him in for his absences, a lot of times they were attributing these absences to physical ailments. He's just sick, he's sick, he's sick. So the school on their record is marking just, physically ill. And so then when GE was in 7th grade, the parents did seek services under Section 504 and or the IDEA. And then just before 7th grade, they had filed a due process complaint for the failure, for violation of child fine. So the school's failure to evaluate previously. At that point, the school said, okay, fine, we'll do an initial evaluation for IDEA. But then parents said no. And instead they got their own assessment completed. And so this, looking at assessments, the school agreed that GE had an impairment, but they said he doesn't qualify for an IEP because he's doing so well. He doesn't require that specially designed instruction. So he doesn't qualify for IDEA. And also, there's no adverse impact. They said they would reconsider, after getting more private evaluations that the parents were in the process of getting. But then when the district asked to evaluate him for 504 now, parents asked to reschedule and then never followed up. So there was never a confirmed date for evaluating for 504. And then during 7th grade, so again, there's still no confirmed eligibility because there's no 504 evaluations going on, and he was already denied eligibility under IDEA. So then while he's kind of in this limbo, mental health struggles are escalating. He goes into a part-time hospitalization program. He gets on homebound services. And so again, the district reiterates their request at this time to do 504, saying, hey, we'd like to evaluate for 504 now. Parents say no. And then at the start of 8th grade, a due process complaint is pending at this point, and the ALJ orders parents to, make GE available for an evaluation. And parents, again, kind of get difficult with that. And so they make him available for the evaluation if they're required to, but then they don't go to the meeting to determine eligibility. And instead, they just want to move forward with due process on child find, looking specifically now at fifth to seventh grade, saying that the absences alone should have triggered a child find obligation there, and that the district violated 504 by not evaluating previously. And the court says no, like none of this is holding up underwater. They said, first of all, when you're looking at 504 and child find, you have to show more because 504, the private cause of action under 504 comes from either disability discrimination, meaning you were treated differently than a peer based on your disability, or you have to show a failure to accommodate. You can't just, say they didn't do child find. That's not going to create your cause of action to file on. And then similarly, under IDEA for child find, the school has to act reasonably. And in order for the school to act reasonably, the parents also have a responsibility to cooperate. So here, again, looking at a 504, there was no allegations that GE was treated differently based on his disability. And even if the parents were trying to allege a failure to accommodate claim, saying that the school knew of a disability and they didn't, address it with accommodations, the parents didn't provide enough proof. They didn't show that the district ever received a final copy of the private evaluation that would have shown specific accommodation needed. And even though the school was aware of the anxiety, again, because all of the reports from the parents were that these absences were related to other physical ailments, there was no reason for the school to, go one step further to suspect there was any connection to the disability that required accommodations. And that's where the parents failed under child find too. Even though the behavior did worsen after that initial ineligibility finding, again, prior to that, there was no real connection between the absences and the disability. And even between September of 2019 and moving forward, the school can do reasonable alternatives. They can monitor the situation, they can observe, they can try to put in other supports. So looking at October to February, it was reasonable to not jump into another evaluation when they had just found him ineligible. And then we got COVID. So COVID really threw everything into a mess. And so the court said that was a reasonable time frame. And also, again, citing the parents' lack of cooperation. They kept refusing the 504 evaluations. They weren't cooperative in attending meetings. They were asked to reschedule, didn't follow up. So the school, in a sense, was acting reasonably by trying to ask for these 504 evaluations, and the parents just shut them down. So what that means for you, a few different things here. So first of all, again, if you're looking at 504 and wanting to file a complaint under 504, you have to show either discrimination, being treated differently, or that known failure to accommodate. And again, if you're looking at the failure to accommodate, you have to show the school had that clear notice. So you can't just say, well, they should have known. No, you have, in the moment, I would say, again, if your child's having a lot of absences, put the school on notice. Hey, as you know, my child has XYZ diagnoses. As one of the symptoms of this is he really struggles with his behaviors in the morning or his, mental health in the morning and can't get to school. And so he's running late. And so I need some support first thing in the morning, or we need to provide some incentives to want him to get to school on time, or, he does this because of his disability. So always putting the school on written notice, linking whatever the issue is to the disability. And if the school is asking to evaluate, make your child available. If you don't trust the school, under IDEA specifically, the school does have a right to evaluate first. So you do need to make the child available for that. But you can also get your private, either if you have the funds, do it on your own. Otherwise, once the school evaluates, if you disagree with that evaluation, you can ask for an independent at the school's expense. So definitely make sure that to that extent you are cooperating with the school, because even if you ultimately disagree with what the school is determining, you still want to have the record that shows you were cooperative. And so there's a good objective reason for why you're disagreeing, and it's that their documents don't match the reality that's happening. And then, so similarly, if the school did just evaluate your child and the week after he's found ineligible, he's worse again, that one worse incident is not going to re-trigger the school's child find evaluation. And again, this is where writings and documentation become so important, is you need to start creating that record to show, this is why you got it wrong. Like you said, he's not, but we're already seeing this and it's only been a week. And I would argue there too, that's a good point to bring up your right to an independent education evaluation if you haven't already, to say, look, you found him ineligible. It's only been a week. We're still seeing the same issues, now worse. I would like an independent evaluation to, reassess his eligibility. Similarly, again, if the school is pursuing those alternative supports, make sure they're clearly documented and make sure you're noting in writing to the school why you agree or disagree, of whether they're sufficient. And again, lastly, just to reemphasize, make sure you're cooperating with the district, because especially whether it's a federal complaint or a due process complaint under IDEA, the school is going to paint you out to be very ridiculous, very uncooperative, very angry. And so the more that you have documentation showing that you were kind, you were courteous, you were cooperative at every step of the way, and just being fair and assertive and advocating for your child and sharing your concerns, that argument loses any, reliability, because the judge or the hearing officer can look at your documents and say, okay, well, clearly the parent was being very professional and respectful and reasonable in this case. All right. Oh, go back one slide, Renee. There we go. All right. So now we're going to jump down a bit to Sixth Circuit District Courts. So with how the hierarchy goes, so in the United States, we obviously have the United States Supreme Court, and then we have our circuits, and then every circuit has its own district courts. So it kind of like, think of like a pyramid. So the district courts are at the bottom of that pyramid. And in terms of what I would say binding case law, so if you are in Sixth Circuit, Michigan, those Michigan cases, particularly whether you're Eastern or Western, are going to have the most binding authority within your district. So the Western District case, Michigan case, is going to have the most binding authority in Michigan. Eastern District is likely to follow it as well, but they don't necessarily have to because they're separate districts. But within the Western District, they do need to follow that precedent unless there's a good reason to overturn that precedent. And then similarly too, like Michigan, looking at an Ohio case, they're going to give that some weight because it's within the circuit, but because it's a different state, different district, they're not necessarily required to follow it. And that's kind of how these cases make their way up the chain, is if there's district splits, the Sixth Circuit might take a look at it and say, hey, we got to clean this up. Similarly, the United States Supreme Court looks at our circuits and say, ooh, there's circuit splits here. Let's clean this up and give the country a standard. So here we're looking at that bottom tier, the Sixth Circuit District Courts. And we're starting with JA and MA on behalf of GA versus Royal Oak School District. And this is out of the Eastern District of Michigan from last September. And so JA was a student, numerous disabilities, really interfered with emotional regulation, behaviors. Really the biggest ones were elopement and physical aggression. And so the school started looking for a different placement. Specifically, they wanted to put JA into a center-based program, moving him from the general education placement where he was. Parents disagreed with this placement decision, saying, hey, you haven't done enough supports. And specifically, they had a few key disagreements with the district's proposed IEP doing this change of placement. Specifically, they felt that the district didn't provide for extracurricular activities, which is required under IDEA. The district didn't provide enough sensory supports. They had removed JA from community-based instruction. The behavior intervention plan wasn't appropriate, and they hadn't appropriately trained the staff regarding JA's fetal alcohol syndrome disorder. And so they had these key disagreements. They filed due process saying, hey, the placement and all of these issues denied, sorry, I messed up my typing here, denied JA FAPE. And so they argued that, yes, JA requires a private placement, but not this center-based one that the schools are trying to push him into. And so the hearing officer at the ALJ did find in favor of the parents at the placement issue, not specifically, but they did say that the district had already moved JA to this new center-based program before having an IEP, which essentially was predetermination. So it denied parents that meaningful parent participation. So the school should have had the IEP meeting with parents first, let the team come to a consensus, and then if that consensus was to move JA, then they should have moved him, not first. However, regarding the parents' other agreements on the curricular supports, sensory supports, the BIP, all of that, they ruled in favor of the school. The ALJ ruled in favor of the school, so the parents appealed. And so the issue for the federal district court was the ALJ wrong in finding no denial of FAPE on these other disagreements? And the district court said no. The ALJ was, perfectly reasonable in his decision. Looking specifically at these disagreements, because this is where the next steps for you will come in. So the first one was, again, that removal of extracurricular activities. And the district said, district court said, well, yes, the IEP should include a statement about the participation in extracurricular activities. The parents failed to show that this specific participation was necessary for FAPE. So really it amounted to a procedural violation, but there was no substantive harm. Additionally, what evidence was provided showed that the district had provided accommodations for JA's participation. And so and then unfortunately those accommodations didn't work out. But the fact that the accommodations didn't work didn't by itself amount to a denial of FAPE, again, without more from the parents showing that some specific participation was necessary for JA to receive FAPE. And then the next was that lack of meaningful classroom assignments or sensory supports. Here, the parents just didn't bring enough evidence. They only had 1 or 2 emails to show that there were inappropriate assignments, and that there weren't sense, and that he was denied access to the sensory room. And then on the flip side, the district provide more evidence saying that, hey, JA had his aide the entire school day, and he also had his BIP. And so because the parents only presented these 2 emails and then also failed to really directly address the school's contravening evidence, saying, hey, we did a great job with this, there just wasn't enough evidence to be in favor of the parent. Similarly, removal from community-based learning. The record showed that, so the general classroom that Jay had been in was had a lot of community-based learning in it. There were a lot of field trips. However, JA's skills were actually more advanced than his peers in this classroom. And so as a result of that, because he was more advanced, when they were going on these community-based field trips, he was more disruptive. He was doing some unsafe behaviors because he just wasn't engaged in that community-based learning. And so the ALJ and then also the district court said, look, if he's not even engaging and he's more advanced than what this classroom is proposing, it's not a denial of FAPE to say, hey, we got to move him, because keeping him there would actually be the denial of FAPE, because it wasn't providing that appropriate instruction. And then regarding the behavior plan, the ALJ, he reasoned, and the court agreed with this, that, you're not meant to look at just fetal alcohol syndrome disorder with the behavior plan. Similarly with the training, you don't need to look just at this. The purpose of a behavior plan is to address what the behaviors are, not necessarily the specific underlying disabilities for those behaviors. And so here the parents didn't show any evidence that, the BIP, was bad at addressing the behaviors versus just the disability, and how that, the BIP would have looked different had it addressed the FASD more. So again, the parents just failed to provide the evidence there. And then again, with the training for the parapro, similarly there, the parents failed to show what other training would have been required and how that would have made a difference in JA's FAPE. So again, there was some training, but the parents just failed to connect why this specific training was required for FAPE. And also too, the district had shown that the training they did provide to the parapros was more than just some short videos. It was a much more substantive training. And then lastly, with private placement, again, with the district court, agree with ALJ's decision to say, hey, the school kind of did this out of order in regards to the parents' argument that, it's private placement was necessary, not just a center-based program. The parents failed to, present any specific ones for consideration. So, for example, in Michigan, I know we have Eaton Academy. We also have one in Kalamazoo called Kmetz, and these are private placements that young parents failed to say, hey, I want him at Kmetz, or hey, I want my child at Eaton. So because there was none of that specific placement, there was nothing for the judge to consider on whether or not that would have been appropriate. So overall, what this case means to you is evidence matters. You have to build your case. You have to be able to say, look, with those extracurricular activities, you have to be able to say, look, my child really has a strength in this extracurricular activity area, or because of his disability, he tends to be very sedentary. So we need to get him in an active sport because that's going to help his physical development. It's also going to help his engagement in school. So he's, talk with your doctor, get the buzzword language, but you have to show why an extracurricular activity is necessary for FAPE, not just that you want him included. Similarly with, training purpose, training and BIP, adequacy, you need to provide more than 1 or 2 emails. Like, it's a balance, because you don't want to be bugging the school every single day, because that's going to seem unreasonable. But, maybe if you're having these issues with the school, maybe send like a bi-weekly email of like, hey, these are some things I noticed the last couple of weeks and that I'm concerned about. Just striking that balance between keeping the school on notice, tying those concerns and what's needed to the disability. And again, like with a BIP, hey, I talked with my doctor and these are some specific FASD accommodations that can go into the BIP to address this specific behavior you're seeing. Again, tying A to B to C. You have to be able to show that to have the chance for success at the due process level, and again, then at the district court level. So looking at BH versus Ohio Department of Education and Workforce. So this was a case where the Disability Rights Ohio, they actually brought a class action against the Warren County Educational Service Center and other school districts alleging violations of IDEA. So the Ohio Department of Ed did find some violations. They issued corrective action plans. They included awards of compensatory education. And one of those cases was BH. And so BH was one of the ones, and they cut the hours from, they initially awarded BH 109 hours. However, once the school districts and the Warren County got all of these, correction action plans, they were like, wait a second, this is a lot. So they, on their own, reached out to the Ohio Department of Ed and were like, can you reconsider these? Like, can you pause these and reconsider your findings? And Ohio Department of Ed said, sure, we'll pause the corrective action plans and, redo things. So they paused it. They kind of essentially reopened their investigation because they conducted more interviews with the Warren County Educational Service Center superintendent. They did some more interviews with some of the school districts. While they're doing all this, there is no notice to parents going on. They just kind of put parents on the sideline and said, you guys are fine, just wait off. And then so after doing all these interviews with the school staff, they modified their awards. And so specifically in BH's case, they reduced the hours from 109 to only 35 hours. They also reduced the categories of services that he had been awarded in. So they removed 2 areas of service that he could use these hours for. However, and this is where kind of the crux of the issue comes in, is by time that the Ohio Department of Ed issued these revised correction action plans, BH had moved on. He is in a private school. He's essentially doing well there. This case seems to imply. So he's out. However, his parent files this lawsuit saying, look, how the Ohio Department of Ed handled this reconsideration process was wrong. And so they are looking not necessarily for that combat to be increased, but they're seeking what's called declaratory and injunctive relief. So they're looking for the courts to say, this was wrong, and moving forward, you have to do it like this. And they brought it really on everyone's behalf. And so on that case, the Ohio Department of Ed said, you don't have standing for this. You're not having a harm anymore. And so the issue becomes, did the parents have standing to pursue this declaratory and injunctive relief, challenging this reconsideration process, when they only had past injuries, which was, again, that past denial of FAPE, and they failed to demonstrate any ongoing or imminent future harm. And the court said, no, because you couldn't show that the harm for you is ongoing or imminent, you can't bring a suit here. So while, yes, BH undoubtedly had past harm through this reduction of comp ed, the complaint failed to show how that reduction created a continuing injury. And so comp ed can be appropriate for a remedy. So maybe if the parents had shown that, maybe the award would have been more compensatory education services, but it doesn't necessarily equate to requiring that injunctive or declaratory relief. And so here the parents just couldn't show it. And so what that means for you, again, if you want a judgment that's not just comp ed, but you want the courts to specifically say, hey, this is wrong, or hey, moving forward, you have to stop. Maybe there's a policy that you don't like at the school that's discriminatory. You have to show this policy is discriminatory and stop doing it. Here is the harm. You have to show that ongoing harm. It can't just be like, well, previously this was an issue. You have to show that it's still an issue for you moving forward. And then looking at DL versus Michigan Department of Ed. This is a case from last September, and this one takes place in Michigan. So there were 3 Kalamazoo students, all of which had issues really relating down to child find. And that, well, for a couple of them, child find, other ones, it was failure to evaluate. So they all had issues with KPS. And in all 3 cases, the students had filed a state complaint with the Michigan Department of Ed on their specific issues. And in each case, the Michigan Department of Ed said, yep, KPS messed up. Yep, KPS messed up. Yep, KPS messed up. And it wasn't even just these 3. There was actually a number of state complaints that had been filed against KPS on the same underlying IDEA issues. That Michigan Department of Ed kept saying, yep, it's an issue. Yep, you violated. Yep, you violated. So then the Michigan Department of Ed is issuing a corrective action plan saying, okay, you need to update your policy and, clean up some stuff. Then I'll say a few weeks, but within a, period of time, MDE then allegedly looks at these corrective action plans and what the school has submitted. And they say, okay, you're good. Great job coming into compliance. Another complaint gets filed, and it's like a rotating, a wheel that is just going and going and going, and no changes are actually being made and implemented. So, and I actually worked on this case along with a couple other attorneys on our in our firm and our panel. So we brought suit saying, hey, MDE is really the issue here. They are not, the state complaint process is faulty. They're not actually making sure that these corrective action plans are getting implemented sustainably. And so we're seeing the same issue again and again. MDE is not monitoring. And so we, again, brought the suit against Michigan Department of Ed alleging this. Previously, again, going back to that exhaustion piece, we had made sure that our clients filed due process, made it through the due process proceedings to get that final decision. And so all 3 of those due process suits were settled. So we were just, had our claims remaining against Michigan Department of Ed. And so the issue for our case was, can a state educational agency like MDE be held liable for its failures in the complaint enforcement procedures when the underlying denial of FAPE was committed by the local school districts? And the plaintiffs already settled. And the court said, no, you cannot hold MDE responsible for the provision of FAPE. MDE is a supervisory entity. And so, and they also said that, we failed to establish that MDE's oversight procedures created an independent basis for liability. So again, even if MDE's procedures were faulty, the law doesn't seem to create a private cause of action, which is what you need to file a complaint to go after MDE independently for those supervisory responsibilities. And again, the court actually went back and relied on the Elzandani, which some of the language in that decision had talked about, public schools are the local school districts that are actually responsible for the provision of FAPE. And so just because MDE has these administrative processes doesn't make them ultimately responsible for FAPE, which is really the crux of bringing lawsuits under IDEA. So that's why, again, it's a question of how much you can even go after the states. And the court reasoned that, even if the claim existed, based on the evidence provided by MDE, by their consultants, it seemed they were at least trying to fix this. And that, with the repeated child fine violations by KPS, again, going back to IDEA's individualized assessment of everything, that even if these students all had a child fine issue within their complaints, the facts surrounding that led to that child fine issue are different. So it's really hard to create that class action because there are going to be, substantial differences between the individual facts. And so also too, the court looked at this that because we had settled at the due process level, like we were required to, we can't necessarily go after the state for, what they call the second bite at the apple. So what this means for all of us is that it is very, very difficult to hold MDE accountable. So even though their state complaint is imperfect, we still have to be able to connect any denial of FAPE to the state's own active conduct, not just their supervisory role. So again, it just makes it very difficult, but it is something that we are very actively, continuing to actively work on because we do think that ultimately the state needs to be held accountable for some of these issues as well. And then the last district case I'm going to go over is LG on behalf of Gigi versus Kelloggsville Public Schools. Here, the parent, LG, alleged that both the school district and also the intermediate school district denied her son FAPE by developing inappropriate IEPs and also by refusing to move him to a center-based program that was operated by the ISD. So for those of you in other states, in Michigan, we have this really lovely setup of education where the state is broken down into intermediate school districts. They can also be called education service districts, and those intermediate school districts oversee a number of local school districts. And so the parent had requested placement at one of the ISD programs, and the school just said, no, we're not doing that. The ISD was never a part of the student's IEP team. They never provided any services or developed the IEPs. But like I said, they did run this program and they did have the oversight responsibility to oversee their local school districts to make sure that their local school districts were in compliance with IDEA. So again, parent brought suit against both the school district and the ISD. ISD filed a motion to dismiss saying, hey, we're not the proper party here. We have no business in this. Like, we don't even know this student. And the ALJ agreed and dismissed the ISD. We appealed, arguing that they were a proper party because of that supervisory responsibility and also because they did, did have a conversation with the school about the student's potential placement there and if it would be a good fit. And that conversation occurred outside of the parents' participation. So he said they were appropriate. The school district or the ISD also argued that the appeal wasn't timely because, again, in Michigan, so with the due process, you only have one level, and you're supposed to file your appeal within 90 days of a final decision. Because all of the underlying facts were the same against both the ISD and the local school district, the appeal was filed 90 days after that final decision against the due process hearing against the school district. So it was after the 90 days had expired since the ISD's dismissal. So the ISD said, hey, you should have filed the 90 days of us being dismissed because you didn't. It's not timely. You can't even bring this appeal against us. And so the district court did agree with the timing issue. They said that because the administrative law judge had issued different docket numbers and essentially, different timelines, even though they, matched up with the district court case or the school district case, that because this was held under a different docket system, that the final decision there was that dismissal. And so the 90-day clock did start ticking with that dismissal. So that's something to keep in mind for appealing, is that if you are going after two different things, pay attention to those docket numbers and how this is being categorized so that you're not missing that timing window. And then in terms of, they said, even if there was a reason to toll the statute of, that statute of limitations and to say, hey, we can still file after those 90 days, even if that reason existed. Here, we didn't prove it. There wasn't any evidence of the ISD's liability because the ISD was not involved. The ISD didn't go to IEP meetings. They didn't provide any direct staff for those IEP meetings. They didn't develop FAPE. And they're really, even with that conversation, there was no evidence that the student was specifically mentioned, or any specific decisions were made. It seemed to be a more general conversation. So because of that, there just wasn't enough evidence that in this case, the ISD had that buy-in to Gigi's FAPE to be responsible. So what that means here is, again, with ISDs, you can't just look at their supervisory liability, similar to MDE. That's not enough. You have to show that the ISD was directly responsible and took on that direct responsibility for the student's FAPE. And then moving on to the other circuits. So next slide, Renee. So we have a few cases here that we had through the past year. So Third Circuit had a case. It was SM versus Freehold Regional School District. And here, BM is a student, and he was having a lot of difficulty in the morning due to his disability. So he was, a lot of times just late to school or missing school for that first session of the day. And this happened during a 14-month period where his absences, especially in the morning, were increasingly occurring. And so the parents said, hey, you should deny BM FAPE because you didn't reevaluate him or provide him an aid before school. So the real issue here was, was there a violation by not evaluating BM due to his absences, and was the district required to provide an aid? And the court said no, that in terms of an aid before the school day, yes, IDEA requires special transportation, but nothing about that starts the obligation before the school day even starts. And then even if, BM required an evaluation, the district here had already offered an IEP and services, and the student had been approved for residential placement as well. So here that was kind of a moot point. The bigger issue was that there's nothing that requires them to provide an aid during the school day that the court found in this case. So what this means for you is that if your child is experiencing school absenteeism, which means that they're being absent or tardy specifically due to their disability, you need to just really bolster up your evidence. Doctors, psychologists, psychiatrists, counselors, whoever, because there is some gray area of what services then are required. So maybe the school doesn't have to provide an aid first, at your home in the morning to help your child get dressed. But what do they have to provide? Because there is, case law to support that you have to do something to address that absenteeism to the extent that it's disability related. Again, like we saw in the earlier case, maybe that means providing evening school, something. And similarly, if you think a reevaluation is necessary, don't just rely on the school to do it. Just make the ask. Should you always be required to? No. Are we going to look at if there is, merit to a claim that they should have known to reevaluate? We'll absolutely include that as a claim. But just in practical terms, if you're looking at the best interest of your child, if you think an evaluation is needed, just ask for it in writing. And then turning to the Fifth Circuit, we have AP v. Pearland Independent School District. So AP did well in school, was homeschooled for a while, started having academic difficulties in 7th grade, continued through high school. Parents ended up homeschooling halfway through 10th grade. During the same time period, again, we're looking at absences. Apparently, this is a trend this past year in absence cases. So again, we're seeing a number of absences. And so everyone is agreeing that, hey, these absences are really impacting her performance in school. Like, she needs to be in school to learn. And so absences are increasing. Finally, parents filed due process saying that the school should have evaluated, and they believed that AP had dyslexia. The school, after the parents filed, said, okay, hey, we'll do an evaluation. Parents said, no, we don't want it. We're going to do our own independent. So they did that at the advice of their attorney. The independent evaluator found that there were disabilities in reading comprehension, math computation, and math reasoning, but no specific dyslexia or ADHD. However, as part of this, the evaluator didn't review any information from the school. No work samples, no teacher information, no classroom observations, nothing. However, again, after receiving the report, the district still offered IEP a meeting to determine eligibility. Parents didn't attend. And because of that, the school said, well, we don't have enough information to determine if AP is eligible or not. And then during the hearing itself, the expert kind of ruined his credibility by A, acknowledging, yeah, absolutely, absences will impact performance, and B, saying, I didn't review attendance data or realize she was homeschooled. And then kind of just the real, shot in the foot here is that he said that the work samples or teacher information wasn't helpful, which when you're dealing with an education case for an IEP eligibility, school samples and information are always, always, always relevant. So the ALJ really kind of dismissed this independent evaluator's credibility and found that the school didn't violate child find, and that the performance issues were due to attendance. And the district court agreed, or the circuit court agreed. They said, look, you didn't tie anything together. You knew, even the parent was acknowledging the absences were an issue. And also one of the things that came up here was the parent insisted on putting AP in some advanced classes that the district specifically said, hey, that's not appropriate for her just based on how she's performing today and with her absences. So what this means for you is, again, documentation and vet your experts. Make sure that you're giving your independent evaluators school information. Put the burden on the school. If you are providing the evaluator all the contact information, they're reaching out, and the school is the one that's not, then it's off of your hands. You did what you could, but you need to make sure that that information is at least offered to the best of your ability. And then also, again, with the absences, if it's disability related, report it as disability related because you need to have that established. And then NE, another Fifth Circuit case was NE, Independent School District versus IM. Again, a lot of disabilities and a lot of really, really severe behaviors. So he at one point had ran away into the road. And because of that, the school had a bit, but they, for whatever reason, stopped tracking those elopements. So the school is kind of creating this documentation to make it look like the student's improving, but practically speaking, he's still being physically aggressive. He's still eloping and engaging in these dangerous behaviors. And so the parents filed due process, and the court said, yeah, like this bit was not good. And the school knew of the grave danger that the elopement was posing. They knew that he was suffering regression during breaks. They knew he benefited from extended ESY, but they stopped providing all of these things. They stopped tracking the elopement. They didn't offer the same extended ESY. And because of that, they needed to do more. That you can't just rubber stamp things. So again, where behaviors are significantly severe, services need to be more than just rubber stamped. You need to be able to show like you are doing everything you can to address those. Seventh Circuit, we had NTV Galesburg Community United School District. Again, number of mental health diagnoses, behavior issues, including elopement. The school did do an FBA and put the student in a self-contained classroom. 3 weeks later, the district ended up recommending a private therapeutic day school exclusively of students with disabilities and a 45-minute bus ride away. And parents said, hey, that self-contained, like that therapeutic day school isn't appropriate. And they filed for due process saying that the day school wasn't the LRE. And the ALJ said, well, the district testimony persuasive that an aide wasn't needed because no one else in the center-based classroom that he was currently in had one, and he received enough. The district, parents appealed from the hearing officer. The district held a bench trial, brought in new testimony, so they had new witnesses, and they had more evidence that showed that while CT had stayed in the initial self-contained classroom, while this due process was proceeding through, he'd actually made progress. And the teacher said the issue was actually that the IEP wasn't tailored to his current placement because of that stay put issue. But even without a tailored IEP, he was still making progress there. So the district court said, you know what? ALJ was wrong. He did not need, CT did not need this private placement, that the center-based program was fine, and he would have just needed additional supports in that center-based program. And so what that meant for you is that, if you are appealing a decision, so say you get an ALJ decision that you disagree with and you're appealing it, don't be afraid to ask to bring in new evidence if you think it will be helpful. Because yes, the court is still going to give deference to the ALJ and his credibility because that's what he was hearing. But to the extent that the new evidence is relevant, that can, shift the case in your favor. 11th Circuit, we had Bryant v. Calvary Christian School. And so this is really under 504. And a student was in a private school having behavior issues. He was diagnosed with autism and ADHD and required some kind of accommodations. Parents specifically wanted the school to provide an ABA behavioral specialist to implement a service plan, in that she wanted to attend school daily, or the aide to do school daily with CB. And the private school said, no, that's going to significantly change our program. It's going to create a disruption to other students. We're not doing that. Your student just can't attend here. Parent filed for discrimination, saying that, she had requested reasonable accommodations. And the court said, no, your accommodations were not reasonable. If a private school placement doesn't typically have one-to-one aides in the classroom, and they're saying that putting an ABA specialist daily in here would restructure their classroom environment, we're going to give them some deference to that. And just because the parents said, well, it would only be, temporary. If you can't give a hard stop date, that's not necessarily temporary. There's no proof that it's going to go away. And so you can't expect the school to indefinitely allow this disruptive accommodation. So what this means for you is that if you are looking at accommodation, don't leave things open-ended. If you're saying I want an aid, you have to be able to say there's an end date. It's here to here, and then it's done. And it doesn't just turn on, the cost to the school. You have to look at, how it's impacting the program. All right, and then I am out of time, but there are slides for you to follow. I did pull up a couple cases to watch. Jacobs v. Salt Lake City. And the reason I think that's an important case is it does look at just your complaint language. So this is looking at hub systems. So school districts tend to cluster their special education programs into different specific schools. And so looking at whether that's appropriate, if you're just saying, well, all the kids with this disability go here because that's where the classroom is, without kind of making that individualized assessment of, does a student actually need that hub placement, or could we just provide some more supports where they're currently at? So that'd be interesting to watch how that handles. And then Sandra v. Upper Darby. I thought that one was interesting because it looks at, and really this is just a district court case out of Pennsylvania, so I'm not sure if it's going to get appealed or not, but it's looking at educational records. And so parent had asked for some and filed a due process complaint saying, hey, the school didn't need adequate evaluation. And parents appealed. So it's just looking at their access to records and if the school had provided enough records for parents to meaningfully participate in FAPE. But they did say that Section 504 doesn't create a private cause of action on the issue because it's statutory, and it's looking at standards. But IDEA, you can bring a complaint under that.
All right. Thank you very much, Jacquelyn. And before we were going to take a 10-minute break, we'll be back. It'll be about an 8-minute break now, but we'll be back at 10:10 for Constitutional Rights for Students Within the Schoolhouse Gate by Nicole Cody. And before you leave, please, attendees, click on the link, the evaluation link in the chat box, and do the quick evaluation for Jacquelyn. Thanks again, Jacquelyn.
Yeah, and I will say too, if anyone has any questions, I know I didn't have time for questions at the end, feel free to contact me at my email and I'm happy to respond to any questions.